Welcome back to another edition of IP series with Rita. Today I will be talking specifically to fashion houses, fashion brands, and anyone who works in the fashion industry. I'm going to also be analyzing two separate cases that focuses on what makes your fashion brand unique. What is that element? What is that intellectual property element that makes your brand unique? Now, in the first case, one party was able to show and prove that their mark was distinctive enough, so they met the basic requirement. While in the second one, they were unable to prove that their mark was distinctive enough and they had used it for commercial purpose. So it's a US and an EU, that is a European Union case, focusing on trademark. I mean, trademark is a very important type of intellectual property right for fashion brand, especially if you wish to stay in the business for as long as 100 years. Especially, I mean, if you look at luxury brand, you find out that most of them have been in business since the 1800s. They started small and they grew to be very popular and one of the leading international. But then you have the smaller brand who saw a gap in a particular industry and decided to monetize it. So you also need to carve a niche in the industry, especially in the fashion industry. So yeah. So, IP friends, as always, I remain Rita and Richinda. If you're the first time listener, welcome to my podcast where I discuss everything intellectual property from trademark, patents, copyright, industrial design, geographical indication, and plant variety. Now, for my returning listeners, you guys already know the drill. Thank you guys so much for always coming back to listen to me. Don't forget to like, share, subscribe, favorite on any of the platforms you're currently listening to me. It will mean a lot to me. And super excited that I crossed 5,000 streams/plays on Anchor. I mean, the first 5,000, and now I am counting down to my 100th episode as well. So you guys, this is my 90th episode, so 10 more episodes and I will be celebrating my 100th episode. But yeah, let's get into our juicy story for today. Okay, so I don't know if I should start with the most recent. It's not like a recent case, but when it crossed my timeline again, I was like, okay, I need to do like a comparison between these two cases and also show the importance of protecting elements of your trademark in the fashion industry. I mean, we need to start having strategy. We need to start having, or even competing with like leading international fashion brand. I know we already have leading fashion brand in Nigeria and Africa, but I think with intellectual property we need to do a lot more. I mean, the fashion industry is a vast industry. You're talking about legal structure, manufacturers, carving a niche, etc. But I'm going to focus today on just the intellectual property aspect of the fashion business. So our most recent case regarding the four-stripe mark owned by Thom Browne. Initially, he started this business 15 years ago, and he started as a sportswear and an athletic style footwear brand because of his love for sport. He was inspired by his use of varsity stripes. So in 2005, rather, Thom Browne started his brand using a 3-bar signature for branding. But 2 years later, that's like in 2007, he got a cease and desist from Adidas, asking him to stop using the three-stripe mark/logo because it was their trademark. So he had to do, rebrand, and then started using, a 4-stripe motif mark instead. I mean, Adidas have been in business since the 1950s, and here is another company coming out in the 20s and 20th century. I won't want to say imitate, but they were kind of inspired by a whole lot of things. But Adidas being who they are, always monitoring that trademark. We're like, nah, we're not having any of that. You gotta stop using the three stripe motif mark. And luckily for them, Thom Browne adhered to what they wanted. So, changed the vase using the four stripe motif mark. Now, fast forward to 2018 now. Adidas approached Thom Browne. They haven't seen that, this small brand that started in 2005 have started making waves in the sports industry and the footwear industry where I'm like a leading person, like a trailblazer, atlanta, etc. So they approached Thom Browne hoping that they will settle via mediation. So mediation is another form of alternative dispute resolution mechanism where if parties don't want to go to court, they can opt to submit to mediation, so that it's more like a private, informal setting, and parties get to decide, they negotiate, and at the end of the day, they draw up their terms, and it's read as a consent judgment. So the other to settle out of court via mediation, and that happened because Thom Browne applied to trademark the red, white, and blue stripe and had already started selling sportswear. But it turned out the negotiation broke down 3 years later. That is in 2021. That's like basically 2 years ago. And because of that, Adidas decided to file a suit. But then Thom Browne's brand was already considered to be like a luxury brand, while Adidas is like just an ordinary. It's not an ordinary sportswear company. Don't misquote me, guys. But I mean, in the sportswear industry, Adidas is like king. I'm not even going to go into the whole, how they came about, but let's just stick to our conversation for today. So after the mediation broke down, parties were like, okay, we can't settle, we can't come to an agreement, we can't meet in the middle. I just was like, okay, next step, going to court. So they filed a trademark infringement suit and trademark dilution against Thom Browne in a New York federal court, stating that Thom Browne, so I'm going to be using TB at some points, not tuberculosis, guys. Okay. But yeah, they stated that TB was selling athletic style apparel and footwear featuring 2, 3, or 4 parallel stripes in a manner that it could be confusingly similar to their 3 stripe marks. Now, Adidas is known for its proactive nature in protecting its 3 stripe mark. And if you just Google Adidas trademark suit or intellectual property infringement suit, you'll see that they've sued a whole lot of brands such as Forever 21, Marc Jacobs, Ralph Lauren, and others. And in 2017 alone, that is a year before they started this whole negotiation, they filed like 50 lawsuits suing popular brands for infringing on their 3 stripe mark. So you see, they always win. So one thing as a fashion brand you need to learn from this is the act of trademark monitoring your trademark, so a third party does not take advantage of your reputation, your goodwill that you have amassed over the years. Because another important thing again with trademark is that you must have consistently used that mark for commercial purpose. But then at some point I'm going to state 2 very significant things from the Nigerian perspective and also from one of the cases perspective as to how they get to analyze all of these things when there's a trademark infringement suit or a petition for cancellation or invalidation of a trademark. So moving on, Adidas was claiming that in their suit, so when you file a lawsuit you have to put in your claim. So they claimed $8 million, which was $8 million. $8 million broken down into $867,225 as damages, and 7,011,961 as profit. That's about that for that case. Now the second case focuses on how fashion brands can create distinctive marks, how they can meet the distinctive test, what are the registrable marks that is permitted in the fashion industry, description of goods in a trademark, procedure for trademark registration. I think I've mentioned that in one of the episodes, but I might just talk a little bit about it. Then also talk about effect of registration of a trademark, but I'll be giving you the Nigerian perspective about that. We're talking about our case, and then territorial distinctiveness, especially in the fashion industry, how fashion brands can conduct IP due diligence when it comes to infringement. So Louis Vuitton, a fashion brand that was founded in 1854 in Paris, France, which happens to be a well-known brand for its luxury products ranging from bags, leather goods to ready-to-wear shoes, perfumes, watches, jewelry, accessories, sunglasses, books, and is also one of the leading international fashion house in the world. Now, sometime in November 2008, Louis Vuitton obtained an international trademark for its Damier Azur pattern for goods in class 18. Now, remember that when you're doing a trademark registration, you have 45 classes to pick from. Class 1 to 34 is for goods, 35 to 45 is for services. So they registered in class 18 for luggage, bags, and other leather product using the International Bureau of the World Intellectual Property Organization. Now, this suit began in 2015 where a third party by the name Mr. Norbert Wisniewski, I'm sorry. So I'm sorry that I murdered the name, but yeah, Mr. Norbert applied in the EU that Louis Vuitton Damier Azur pattern was not distinctive enough, and so a petition that the mark be cancelled in the EU. And the European Union Intellectual Property Office, which is also for short EUIPO, ruled and declared that Louis Vuitton's Damier Azur pattern was not distinctive enough. They also rejected their argument that the mark, on the basis that the mark had not acquired distinctiveness through use in line with Article 7, sub 1, paragraph B of the European Trademark Regulation. So you guys please check it out. And one thing I need to point out here is the fact that in the EU, distinctiveness is based on use. You get? Whereas in Nigeria, what our act provides is that the mark is capable of being distinctive. So I'm going to explain further down the line. Now, under that act, it stated that grounds for declaring an application that is a trademark invalid is that one, the as Louis Vuitton had not done the registration, had done the registration in bad faith when they filed the mark, and while subsection 2 further provides that the trademark may not be declared invalid if it has acquired distinctiveness in relation to the goods or services. But in this case, the EUIPO declared and gave their judgment that Louis Vuitton's Damier Azur pattern had not met that basic requirement. Then Louis Vuitton appealed. So one of the benefits of this is that If a trademark registry or an intellectual office gives its ruling on a matter, you have to go through the administrative procedure, the next court or appeal board to make your claims, appeal further up until the final court, as the case may be. Now, Louis Vuitton applied to the second board of appeal of the EUIPO. They also dismissed Louis Vuitton's case and aligned their, reasoning with the EUIPO. Then, sometime in June 2020, the General Court, per the appeal, decided against Louis Vuitton again and agreed with the Board of Appeal that the Louis Vuitton Damier Azur pattern lacked distinctive character. Now, what can you notice about Louis Vuitton and Adidas? Now, in Adidas' case, Adidas was, is known as a proactive brand that is always trying to protect their trademark. In this case, Louis Vuitton is seen to want to get the right to be able to prevent other persons from exploiting the Damier Azur pattern, as the case may be. So, because trademark acts as a source identifier, it functions as a source identifier, it gives you exclusive rights to monetize it, as the case may be, and you must consistently use it. So there are grounds for where you make petition that someone has not used their mark for a while, but that was not the case here. Mr. Norbert was applying that the mark was not distinctive enough in use. Because one, trademark is territorial in nature. Secondly, it's not in every part of the EU that the Louis Vuitton Damier Azur mark was known as being distinctive or someone could recognize it. And that's another thing again, a beauty about trademark. Sometimes the consumers have the final say when it comes to an infringement dispute or a petition for whatever reason. Now, 7 years later, so this case, remember I said this case started in 2015. Yeah, it was filed in 2015. So since 2015 till now, this judgment came out last year. And I guess for some reason, it just kept popping up on my timeline, and I was like, what is going on? So when this Thom Browne's case against Adidas, I was like, okay, these are two very interesting fashion cases that I should analyze. So 7 years later, that means yesterday, last year, the EU General Court, also known as the 10th Chambers, agreed and confirmed the EUIPO decision that the Louis Vuitton Damier Azur pattern had not acquired distinctiveness through use and so can't be registered in the EU as a trademark. I mean, that's really sad. So what does acquired distinctiveness mean? So the court defined that to mean, one, that the market share held by the mark. What is the market share of the Louis Vuitton Damier Azur bag? What is the intensity and the geographical widespread and long-standing use of the mark? So I know when I was going through the document, I came across a place in one of the posts where it stated that in certain parts of the EU the mark were not protected there. I know you have the regional IP registration. Louis Vuitton had opted for the international registration using the EUIPO, but then certain countries were not selected. So when you decide that you want to expand or branch out to another territory, it's very important that you do the registration to cover all that jurisdiction. I know last year we had a case in Nigeria where a famous mark was, according to the court, stated that as it stands now, famous mark in Nigeria doesn't really mean anything too. If you're a famous brand, you need to come here and register your mark either as a word or device mark so that you're protected, or don't just rely on your reputation and goodwill. The court also stated the amount invested by undertaking in promoting the mark. So what has Louis Vuitton done in promoting the mark in all of that jurisdiction in the EU? They also explored opinion polls where consumers' opinions were sought, Finally, statements from the Chamber of Commerce and Industry or other trade and professional associations. So if you're a fashion brand owner, you work in the fashion industry, please make sure you are collaborating with all of these persons. Make sure you are visible, you're all up in their face, so that in the event of such issues now, like the Louis Vuitton, Damier Azur pattern, you will be able to prove that your mark is distinctive through use, or is capable of being distinctive, or is distinctive enough because it's unique based on your jurisdiction. So always negotiate and have discussions with your trademark attorney or your trademark law firm or the law firm or your retainer. And yeah, so let's go back now to the previous case, and then I'll come back to lessons that brands can, fashion brands can take note of from both cases, or specifically from this case. Now, a very important update from the Thom Browne case against Adidas is that so this that okay, so let's say on 12th of January and 12th of January 2023, an 8-person jury found in favor of Thom Browne that his 4-stripe motif did not infringe on Adidas' 3-stripe mark. I mean, I think everyone was surprised, and I'll give kudos to the counsel, that is the lawyers who represented Thom Browne. I mean, they put up a pretty good case, because I think this case took about 2 weeks, and they came back with this judgment and held that trademarks are like fingerprints for brands, and they add brand values, they protect brand quality, which is part of the benefits of a trademark. You're able to do business and commercialize your trademark either by licensing your mark, or where you get to earn royalties, like Tom Ford and Estee Lauder. Before they sold last year, they were already licensing from Tom Ford, and in that agreement, that is the sale, they transferred all the intellectual property rights, their collateral for mortgage and loan, and also sold the company as well. And trademark, one thing you need to know is that trademark can last as long as the company is in business. So remember I said Louis Vuitton had been in existence since the 1850s, so 1854. Yeah. Now, why those in the fashion industry should take trademarks seriously? Like, it's not my mind. Brand protection in the fashion industry. First, in the event where your trademark is infringed, you need to look out for certain things. One, how similar are the marks in appearance, in pronunciation, verbal translation, evidence of likelihood of confusion amongst your consumers. If someone sees the 4-stripe motif mark, would they confuse it for Adidas? I do not think so. I mean, if it's a black socks and I see 3-stripe and I see the other one black stripe, I don't think I would generally. Then the strength of the mark in question. Is it a suggestive mark? Like if they hear your name, like someone know, oh, this is like, if I hear Apple or something, is it arbitrary? Is it descriptive? If they hear cold ice cream, it's too descriptive for the name of a dairy product. Is it generic? Noodles, Indomie. Everybody calls all the noodles brands in Nigeria Indomie. It has become a generic mark. I think Indomie noodles should do something about that. Is it a fanciful name like Padu Prime, or Adidas, or Nike, or Louis Vuitton, or I'm just thinking. Let's see. But anyway, moving on. Would a typical buyer be able to exercise ordinary caution when they're trying to buy your brand rather? What is the intention of Thom Browne in selecting his 4-stripe motif? Was it to cause confusion or be confusingly similar to the Adidas 3-stripe mark? The relevant market Adidas and Thom Browne are being sold. Do they use the same marketing channel? Remember that both brands are now in the footwear business. Is it also possible that both Thom Browne and Adidas are connected to the minds of consumers? For instance, Are they related but not competitive? Are they unrelated and there's an unlikely confusion? Now, trademark infringement, just like any other intellectual property right, occurs where a mark, be a name, word, logo, sign, symbol, color, smell, shape, motion, it's affiliated with the brand. Affiliated with the brand is used in connection with goods or services to cause confusion, misrepresentation, to deceive consumers that, oh, if you get a Thom Browne, you're as well getting an Adidas, or an Adidas is basically just a Thom Browne footwear or athletic product. Would they mistake the source of origin of the brand? Those are the things you need to consider when you say someone has infringed your trademark. Now remember that the Thom Browne case is a trademark infringement case, whereas the Louis Vuitton case is a petition for cancellation and invalidation. It can also be said to be a clear violation of the intellectual property right accorded to the fashion trademark owner, without their consent, permission, authorization, which I tag as CPA, by commercializing and exploiting the exclusive rights in the distinctive mark registered and in use. Now, what if the infringement happens to be an unregistered trademark? Now, know that unregistered trademarks, if you own a fashion brand and you haven't registered your trademark and you've used it for at least 5 years in Nigeria or 3 years in the US and in the UK, yes, in the UK, you have a limited form of intellectual property protection, and you can sue for passing off if you can show that you have used the mark for the number of years that I mentioned. Okay, so it's 5 years in the US. Apologies, guys. Now, moving forward, Adidas also alleged that TB use of the motif, that's the stripe motif, was a clear violation of their famous mark, and they sued them for trademark dilution, which occurs where two brands or product or services are not even competing with each other, but based on the subtypes, which will be dilution by blurring, TB mark may be considered to be similar to Adidas and may affect Adidas distinctiveness, or dilution by tarnishment would occur where an association of TB to Adidas could ruin or harm their reputation as a famous mark. And to be honest, that's not even the case here. At least for me, that's not the case here. A trademark dilution claim would only apply if the commercial use of a mark has been exploited. Now, what are the I was going to talk about the trademark remedies, but let's move on to the other case as to lessons that fashion brands can learn from when your mark has been petitioned before a trademark board, that is an IPO, or your mark has been infringed. So before I proceed, I'm going to refer you, just Google it. The distinctiveness test in Nigeria can be found in rules 22 of the trademark regulation. Let me just read what it states. Now, rule 22 reads, says any person who proposes to apply for the registration of the mark in either part A or B of the register in respect of any goods may apply to the registrar, informing them that he's making an application under regulation 118, and they are seeking for advice as to whether the mark of which duplicate representation shall accompany the form. They would appear to the registrar prima facie to be inherently adapted to distinguish within the meaning of section 9, or inherently capable of distinguishing within the meaning of section 10, as the case may be, in relation to those goods, and shall apply separately in relation to goods. So that's plenty law thing. But basically, like I said, under the Nigerian IP system, we have ways for determining distinctiveness. One, you're either capable of distinguishing your mark, or you're adapted to distinguish within the meaning of section 9. So let me read section 9 if you guys permit me to do so. Yeah. Now, Section 9 lists the qualities of what can be registered. So you can register the name of a company, individual, or firm. You can also register the signature of the applicant. You can register an invented word or words. You can register you can register words that are not descriptive, that they carry any defect or reference to the quality of the goods, and then any other distinctive mark. While Section 10 talks about capability of distinguishing required for registration in Part B. So make sure that when you're doing registration, your trademark agency is properly advising you on what you really need to know when it comes to registering a mark. You also need to pre-inform them that the fact that you're registering your mark or applying for a mark does not guarantee that you would get the mark registered. You might get to a stage where your mark application may be rejected for not being distinctive. So make sure that you have that discussion and also put out a disclaimer. So my disclaimers is I have advised you that your mark is not capable of distinguishing, but I've decided to go against my legal advice and asked me to proceed with your registration. Just to protect yourself as the agent. Then what can you not register? You can register a deceptive or scandalous mark. You also can register names of chemical or substances, or identical or resembling trademark cannot be registered. So remember that the Thom Browne case is a trademark infringement where you're talking about identical or resembling mark. That is not the case here. The first stripe motif is not identical or resembling Adidas 3-stripe mark. You also cannot trademark the word patent, patented, registered design, copyright, to counterfeit. This is to forgery. You can't register a red cross or the Geneva cross or the representation of the cross or the arms of Nigeria. Now let's talk about procedure for registering a trademark. First, Rule 33 of the trademark registration provides that upon receipt of an application for the registration of a trademark in respect of any goods, the registrar shall cause a search to be made amongst the registered mark and pending application for the purpose of ascertaining whether they are on record in respect of the same goods or description of goods, any mark identified with the mark applied for or so nearly resembling it as to render the mark applied for likely to deceive or cause confusion, and the registrar may cause the search to be renewed at any time before the acceptance of the application, but shall not be bound to do so. So before you do a trademark registration, you have to do a search to determine whether that mark is available or not, either from the pending registry applications or already approved applications. So you get a response from the registry. Now after that, you move to the acceptance, absolute or conditional objection. That is under Rule 34, which says after such search and consideration of the application and of any evidence or use or the distinctiveness or any other matter which the applicant may or may be required to furnish, the registrar may accept the application absolutely, or he may object to it, or he may express his willingness to accept it, subject to such conditions, amendment, disclaimer, modification, or limitation as the case may be. So sometimes when you do registration, the registry may say, okay, this is kind of similar to this, but add X, Y, Z, and to make yours different, and continue into your application. Then Rule 35 says the registrar's objection and hearing. If the registrar objects to your application, it shall inform you, the applicant, of his objection in writing, and unless within 2 months the applicant applies for a hearing or makes a considered reply in writing to this objection, it shall be deemed that your application has been withdrawn. So if you get a response from the registrar and you don't act on it, they will consider that you have withdrawn your application. I know that was also, I think I came across this when we were talking about the Afrochella case, where it was stated that the US Patent and Trademark Office had issued an objection to Afrochella's registration of Afrochella in the US, and they had like a timeline to object for the hearing was 2 months, but Afrochella never responded. So you guys can also listen to that episode, and yeah. So that's about it for procedure of a trademark registration. So talking about trademark remedies, in the event of a trademark infringement using the Thom Browne case. First, you can apply for injunction after the following has been considered: one, public interest, damage to Adidas mark, the effect of the court granting the order, account of profit after showing to the court um, that there was a consumer's confusion, but proof of trademark registration must be attached. That is the one that has the R inside the circle. When you see that, it means the mark has been registered. If you see TM inside the circle, it means it's not been registered, but it's in use. If you see S, that is for service mark. So other intellectual property to also consider: first, trade dress, for the overall image of the product or services, which will include the color, shape, size, packaging, product, anything that makes the presentation of your mark distinctive. Now, for trademark infringement, this is what you're going to be focusing. Whereas where it is a petition for invalidation or cancellation, the whole ball game is different. It's also very important that you know that trade dress prevents other companies from using unfair practices to compete with you. Copyright is another form of mark that fashion brand, houses, and those in the fashion industry should take note of. So you have promotional material, brochures, sketchbooks, prints, images, photographs, two-dimensional work, not your name, not your title, not short phrases, anything in a fixed or tangible format. Then design right protects the combination of lines, colors, or bold, or three-dimensional shape, or the visual appearance of the product itself. Then patent for any technical innovation that gives your fashion brand competitive edge that is new, includes an inventive step, and is not obvious to a skilled person. So those are like the criteria or basics when you want to patent a work in the fashion industry. You also has to have like an industrial application, e.g. smart textiles. A trade secret protects confidential information of a fashion brand, e.g. the software tools that you use for your fashion design, your key suppliers and buyers, logistic management. All of this has commercial value and doesn't require registration. So copyright and trademark basically do not require registration. However, for copyright, depending on the jurisdiction you're based, like in Nigeria, we apply the depository system where you deposit a copy of your work in the data bank of the Nigerian Copyright Commission, so that in the event of a dispute, you can show proof of documentation. Okay, I am the first author in line with Section 10. The first person who creates the word is the author of the work. Then you have geographical indication, which protects the distinctive sign used to identify a product from a particular region, made in Nigeria, made in China, made in Australia, made in Ghana. And then, the commercial image of a brand too is another IP that some, fashion brands can consider. Now, what lessons can you learn from the Louis Vuitton case? First, as a fashion brand, it's very important that not only does your trademark meet the required distinctiveness test, it must be acquired through the use of a mark within a particular territory, e.g. Nigeria, or the regional application EUIPO or EUIPO, or the EU IPO registration, and also you need to consider what are the requirements for your jurisdiction. Like I said, for Nigeria, your mark has to be capable first, it has to be capable of distinguishing a mark or being adapted distinguishing elements, whereas in the EU, it must have acquired distinctiveness through use. So, because IP is territorial, you also have to have strategies that your mark can use for commercial purpose. Don't play with media coverage of your brand, as it helps your brand to be exposed to the general public. Your mark must be strikingly outstanding, as it is not enough to state that your mark is not capable of deceiving or confusing the public. It is not enough. When your mark is distinctive as a fashion brand, it helps you identify. It helps to identify your fashion brand from that of other brands out there, acting as a source identifier, e.g. the shape, color, symbol, logo, pattern, whatever it is, like the Damier Azur bag now. Why was Mr. Norbert so bent on opposing to this registration. Because another thing you need to take note of, that the burden of proof for establishing distinctive character through use lies with Louis Vuitton, who must adduce specific and substantial evidence for that purpose. So you can check out the Alicante News, which is a publication by the EUIPO. They public, I don't know how often, but if you subscribe to the EUIPO, you definitely get news about it. I know someone, let's see now, there's a lady that made a comment about the case. I'm trying to look for her name so you guys can check it out. Just give me a second, guys. Give me a second. So the author is Lisbeth Moore Yinsen, who is a member of the Fourth Board of Appeal of the EUIPO. So it's like she did, or he did, a case analysis to reflect the opinion. So it's just like what I'm doing. I'm just, doing my own analysis, but it's not going to reflect or affect the position of what the EUIPO has stated or held. Then you also need to consider that consumer are the kings. They are kings when it comes to trademark identification, especially when they can immediately and consistently identify your fashion brand mark when they see it. So if you see a Thom Browne or a Louis Vuitton Damier Azur, I mean, it's a lovely design, but especially in this 21st century, I won't say 20, but recent trademarks have been getting a lot more exposure. The examiners have been doing a whole lot to make sure that it meets that basic requirement of being distinctive or being capable of distinguishing a mark from the other. How do you prevent a trademark infringement? First, you carry out a search, do your IP due diligence, monitor your trademark, register your mark if you within your jurisdiction. If you're in the first to file jurisdiction, like my jurisdiction, which is in Nigeria, first to file is known as a trademark owner. Or if you're in the first to use jurisdiction like the US, find out what applies to your jurisdiction and be proactive. Actively monitor your trademark. Take cue from Adidas, who, they did wait a long time to oppose to Thom Browne's use of the four stripe mark. That's what some IP practitioners have been saying. Maybe, maybe not. But then you find out from all the cases that they filed that they monitor their trademark. Like, they're always on anyone who attempts to use a three-stripe mark in their brand, just like they did with Thom Browne when they initially started in 2005, and Thom Browne had to change their brand logo and all that. Don't wait 10 years to do that. Enforce your trademark right. Now, other issues that fashion brand owners encounter: first, is counterfeiting and pirated and knockoff brands, cyber squatting, domain name dispute, unauthorized use, dubious SEO method, passing off, unfair competition, trademark infringement in the metaverse, exploring intellectual property virtual rights. Yeah, I needed to say that in light of the Meta Becking case, which commenced on the 30th, 29th or 30th. I'm not one of the dates anyways. And then you've seen that a lot of fashion brands are moving into the metaverse and the Web3 and exploring all of this. Then high-tech use of artificial intelligence, 3D printing, not consistently using your mark or abandoning your mark after registrations or when it's been queried, serial and fast fashion copiers, e-commerce liability. So what is then the role of a trademark registrar in determining the distinctiveness test? Now, I'll talk about this from the Nigerian perspective. First, the registrar investigates the application from the moment you apply. When you do your search, you verify that your mark is not similar to an existing one or a pending application. So they ensure that it meets the distinctiveness test in section 10, 9 and 10, basically. The registrar, in this kind of scenario now, can ask the trademark applicants to provide evidence of goodwill acquired in the mark to determine if it can function as a source identifier. In the event of opposition of a trademark or invalidation or cancellation application or any other petition hearing, they can conduct appropriate hearing to that effect, like what the EUIPO have done in this Louis Vuitton's case and the court, the New York Federal Court, in the Thom Browne against Adidas case. And the registrar can reject an application that doesn't meet the distinctiveness requirement. So, when you apply for a trademark, you get your search results, you apply, you get your acknowledgement. So the next stage is that you get an acceptance or a rejection. Don't feel bad if your mark is rejected. You can apply to be reheard. But then, don't feel bad. Now, a mark to register in Nigeria must, I already listed, that must have the following qualities. That it must, in line with section 9, must be an invented word name of a company, individual, or firm, any other distinctive mark, etc., etc. And then the criteria for registering a trademark in Nigeria is that the mark must be capable of distinguishing goods. The EU is that the mark must have acquired distinctiveness through the use. While in the United States, the trademark applicant or the trademark owner must show that the trademark has become known to consumers as originating from one particular source. So verify all of this before you proceed to apply. The ability to actually identify and distinguish your goods, that is for the US. So in wrapping up, not basically in wrapping up, but then if you want to do a trademark registration for your fashion brand, you need to consider class 3, class 9, 14, 18, 23, 24, 26, 35, and 40. It may seem a lot, but it's better that you protect yourself in all of these relevant apologies guys, relevant classes, and also make sure that you consistently use them. Make sure that you acquire distinctiveness in use. Make sure that your mark is capable of distinguishing your brand from another. Make sure that your consumers can identify and distinguish your brand, your mark from another fashion brand. So yeah, I hope I've made sense to all the fashion brands and houses and medias and everyone in the fashion industry. If you're not in the fashion industry and you're listening to me talk today, please share this with someone you know that's in the fashion industry so they'll learn a thing or two. If you have questions, not consultation now, please, just questions. If you want me to review a case, please send an email to ipseriesinfo@gmail.com. Okay, so we've come to the end of the 90th episode. I hope you guys learned something. Don't forget that if you have cases you want me to review, just send me an email to ipseriesinfo@gmail.com. Follow all my social media handles. I'm on Instagram, Twitter, I'm on Facebook as well. I'm partially on LinkedIn, but yeah, most of my content I'll post it on my personal page on LinkedIn. I had a great time doing this research. I hope you learn a thing or two. If you do, please send me a review, and I'll be looking forward to hearing from my IP friend. Love you guys, and see you in the next episode. Mwah!